This is English Shorthand Dictation Legal Matter. Transcription number 14. Ready? Start. The dispute in this petition narrows down to the controversy as to whether the petitioner who has been found entitled to receive the information as per the order passed in second appeal on 7 November 2016 is to be provided on payment of additional fee or is to be provided free of cost. The challenge raised is to the order dated 1st February 2017 with a prayer to quash the same. The contention of the petitioner is that the public information officer who was obliged to provide the information erroneously rejected the application of the petitioner, and in spite of having succeeded in the second appeal on 7th November 2016, the information was not supplied within the period of 30 days as contemplated under section 7(1) of the Right to Information Act 2005. Even thereafter, that is, upon the decision dated 7th November 2016, the situation remains the same. The petitioner is entitled for supply the entire information free of cost after expiry of 30 days. Replying to the said submissions, Sri Shikhar Anand submits that keeping in view the nature of the provisions of section 7(1) and 7(6) of the Act, the said period of limitation in such a fact situation would not be available to the petitioner inasmuch as the public information officer had rejected the application on 20th December 2015 itself, which was within the period of 30 days. Consequently, if the information was not required to be tendered and the jurisdiction had been exercised by the public information officer well within the time prescribed, then in that event the petitioner cannot claim receipt of information free of cost in the circumstances of the present case, where the second appeal was decided on 7th November 2016. More so, where the petitioner himself had filed a recall application that came to be disposed of on 1st February 2017. He therefore submits that the claim of the petitioner being not tenable, there is no infirmity in the impugned order, nor the petitioner can claim the information free of cost. A perusal of the aforesaid provisions leaves no room for doubt that the information has to be provided within 30 days of the application. The admitted position is that the application was rejected within the period of 30 days. The petitioner thereafter filed a first appeal that was rejected on 4th February 2016 and then filed the second appeal, which was allowed on 7th November 2016 to the extent indicated therein. However, while allowing the second appeal, the State Information Commissioner proceeded to direct that the information shall be tendered to the petitioner on payment of additional fee to be calculated as per rules. It is this part of the order by which the petitioner is aggrieved after the recall was rejected on 1st February 2017, contending that the public information officer was found to have not supplied the information to which the petitioner was entitled, and therefore after the expiry of 30 days of moving of application, the information has now to be supplied free of cost to the petitioner. In the instant case, what has happened is that the order had been passed rejecting the application within 30 days. Thus, after the rejection of the application, there was no obligation on the part of the PIO to provide the information. This situation is, however, different where the second appeal of the petitioner has been allowed on 7th November 2016. The question is whether the limitation period of 30 days as provided for under section 7(1) will continue to be available to the petitioner after the said order or not. We find that the public information officer has to be compulsorily present according to the relevant procedure of appeals provided under the 2012 rules. It is not the case of the respondent that the PIO was not informed or was not aware of the order dated 7th November 2016. It is otherwise also not possible inasmuch as if the appeal has to be heard in the presence of the public information officer, then the presumption is that the public information officer had full and complete knowledge of the order dated 7th November 2016. The providing of information of the passing of the order therefore is not an obligation of the part of the petitioner.